A very warm welcome to the listeners of this session. Today we will be discussing upon the concept of law, and this pertains to one of the course which is Understanding Gender and Law, course code BGS 011. Today we will be discussing how the law is defined by different philosophical jurists and what is the nature of law as per those theories and the concept of law. Now the law, if we talk about, is a socially significant and spread or flows throughout in all realms of behavior, maybe social, cultural, moral, religious, etiquettes and so on. Oxford Dictionary defines law as the whole system of rules that everyone in a country or a society must obey. Now, Encyclopedia Britannica defines law as the discipline and profession concerned with the customs, practices and rules of conduct of a community that are recognized as binding by the community. Enforcement of the body of rule is through a controlling authority. Now, the question arises that by law we means the legal provision or it's a social order. So, the modern practical jurists understand by the word law as legal provisions that one practice in general day-to-day life, which are mostly different in different places, among different people, but those who visualize the law in the context of social order, we see law as to emphasize the common elements among civilized states and people in the midst of this variety. Now, if we discuss the concept of law, now how the law is conceptualized. There are general philosophical theories of jurisprudence that attempts to define law and the nature of law. The theory of law advanced by legal theorists are of a particular value and helps to understand the different facets of law and give a complete and rounded picture of the concept of law. Now, some theories, if we look into, they try to define law by reference to its formal characteristics and to the state what distinguishes law from other related phenomena. But others, philosophical jurisprudence or scholars, they may concentrate rather on the content of law and inquire what law ought to be rather than what it is. Yet others stresses the operation of a law in a society and attempts to describe the functions of law as it works in an actual practice. However, the conflict between such theories we can't say it's unreal, it's not altogether real in so far as each theory is dealing with a slightly different aspects of law. Now, the basic object of this session is to discuss nature and concept of law, which is based on various schools of thought focusing on various aspects of law. So, we will start with the first of all, we will start with the natural law theories. We will go to what is the theories given by the positivist analyst, the historical school or a sociological approach. So, all these philosophical schools of thoughts, they have attempted to define the law and the nature of law within their perspectives. So, natural law theories basically provides that law is lex naturalis. It is universal law and is set by nature. Now, it refers to the objective moral truths or behavior which can be known or discovered by use of reason to analyze the human nature. So, theory of natural law was, if we look into it, was earlier proposed by Aristotle. There is in a nature a common principle of the just and unjust that all people in some way divine, even if they have no association or commerce with each other. These are the words of Aristotle. Now, Aristotle conceived the idea of sovereign, laws and justice. On his book, Aristotle conceived this idea of sovereign, law and justice. He believed that law should emanate from a godlike man. So, he is saying a man of outstanding caliber and eminence in virtue and political capacity, which one can say a sovereign, and that there must be a body of laws in a state governed by such man. So, man, he used, when perfected, is the best of animal, but if he is isolated from law and justice, he is worst of all. So, this is given by Aristotle in his famous book The Politics, which is translated by E. Barker in 1946. One of the oldest recorded definition of natural law is also given by Roman orator and a statesman Marcus Tullius Caesar. He asserted that natural law is right reason in agreement with nature, of universal application, unchanging and everlasting. There will not be a different law at a Rome and at an Athens, and different laws now and in future, but one eternal and unchangeable law for all the nations for all the times. So he believes that law is similar for all the people and it should be eternal and unchangeable law. The natural theory which we know known today was codified by Thomas Aquinas, which is quite popular, which we say it's known today to all the scholars. He distinguished 4 different kinds of law. One is the eternal, the natural, the divine and the human law. Now in the Renaissance times, philosophers like Hobbes, Locke and Rousseau, they promoted the idea reason in their theories, which laid the foundation for the modern theories of natural law. In modern times, Finis is a prominent jurist whose idea of natural law has been quite well appreciated. According to Finis, the content of natural law should be made up of basic forms of good. Now he says this basic forms of goods is necessary in ordering any human life. He lists out 7 forms of goods: life, knowledge, play, aesthetic experience, sociability of friendship, practical reasonableness and religion. So we can say that natural law is the standard of supreme law based on reason or God or nature. So natural law helps man to evaluate the man-made laws from a higher standard. The natural law provides an avenue to rebel against unjust laws. So earlier we can say, if we look into India or many other countries, abortion was not allowed. Still it is not allowed because it's due to the religious reasons, and aborting a fetus was considered as a violation of the law of God. Then comes the analytical legal positivism school. Now the theory of natural law has been fairly challenged by this legal positivism school, which is promulgated by a famous scholar Jeremy Bentham and John Austin. The idea which the Bentham and Austin put forward is that law is the command of the sovereign. It was advanced by the writers such as Bodin, Hobbes and Bentham, but the chief expression is found in the writing of Austin in his book The Province of Jurisprudence Determined, which is first published in 1832. Now according to the Austin, positive laws are the laws strictly so called. So he says law is the positive laws. In a society, they have 3 characteristic features. So he focuses on 3 features of law, which he says a type of command, laid by legally unlimited political sovereign, coercive orders that impose duties or obligations on individuals and are enforceable by threat or force or sanction. Now the point comes is, what is sovereign, what is command, which command is law, and what is meant by sanctions. Now to Austin, a sovereign is any person or a body of person whom the bulk of society or a political society habitually obeys. But this person, he is not in a habit, or he himself habitually does not obey any other person, or a person that is sovereign is a determinate person or a group who have supreme and absolute de facto power, and they are obeyed by all or most others, but do not themselves similarly obey anyone else. So in a monarchy, the king is the sovereign, we can say, because he is habitual that others may respect him, but that sovereign person or a group of a person is not habitual to obey any other person. So if we talk about in monarch system, we can say the king is the sovereign. In functioning democracy, the people are sovereign and their will is expressed through parliament. Now what command is law? Now all commands are not laws. For to qualify as law, according to the Austin, a general command obliging a class to act or forbearance must have been given by a political superior or a sovereign. So any command is law if it is given by a political superior or a sovereign. Now what is meant by sanctions? Now sanctions, they basically consist of penalties which is inflicted on the order of the sovereign for the violation of law. In other words, we can say are institutionalized punishments. If a certain laws is not followed, the government imposes a fine, or they have to go through the punishment, which might be an imprisonment. For example, if somebody violates the traffic rules, fine is imposed, and in case of when the offence is it could be punishable with imprisonment also. So there are categories of offences which are punishable with imprisonment or with fine or with both. We can also refer to various the crimes or offences mentioned under Indian Penal Code which are punishable. So that means the sanctions basically consist of penalties which are inflicted on the order of the sovereign for violation of law. Now thus we can say positivism regards law as the expression of the will of state through the medium of legislature. It is objected that this theory conflicts with ordinary usage by denying the name law to rules which are generally classified as illegal. Example, like customary rules are also there, or international rules are there, or much of the constitutional law, as it is not rules which originate from a sovereign command. But the proponents of positive law schools are not concerned with the morals and other informal sources of law, but they only recognize the formal sources of law. Now, if we look into modern legal positivism approach, now this was represented by Austrian jurist Hans Kelsen and H.L.A. Hart, who is a British philosopher, and Joseph Raz. Hans Kelsen propounded the pure theory of law. He says a science of norms. The theory addresses basically the dynamic conception of law, which addresses the process by which legal norms are created and provides a process-oriented account of how these norms attain the validity. So according to Kelsen, he visualized the concept of grand norm. He says grand norm is a basic norm that one's respective legal system ought to comply with. As a general rule, in the hierarchy structure of the legal system, the norm must derive their validity from the others. So a hierarchical structure is created where the grand norm is a basic norm and the other norms, they derive their validity from the other higher norm. However, this is a static conception of law, we can say. For setting out the conditions for valid law, the theory of law must be pure. Legal norms must be distinguished from fields such as ethics, sociology and psychology. This is the view of modern legal positivism approach. A legal norm is no longer considered to be valid if it remains permanently ineffective. However, effectiveness is a condition of validity in the sense that effectiveness has to join the posting of legal norms if the norm is not to lose its validity. So effectiveness is very important for the validity of a particular norm. Now, if we look into the view of Hart, H.L.A. Hart, he describes his own viewpoint as a soft positivism. Now, he attempts to define legal positivism as a theory that there is no logically necessary connection between law and morality. So, they says that natural law says that law should be based on morality, but it says that logically it is not necessary that there should be connection between a law and morality. But at the same time, he admits that rules of recognition may consider the compatibility or incompatibility of rules with moral values as a criteria of the rule's legal validity. Hart constructs a more relative model of law. He says in which a legal system basically arises from the combination of primary and secondary rules. The primary rules of obligations or a society's expectation of one's behavior simply imposes duties and turn into laws via the secondary rules. Now, so what are the secondary rules? These are the power conferring rules, such as rules of recognition, adjudication, change and sanction. Now, Joseph Raz, he describes law as a system of norms providing a method of settling dispute in an authoritative manner. So far we have discussed about the natural law school and the legal positivism. Now, it is very important to know the approach of historical and anthropological schools. Basically, the main representatives of this school are von Savigny, Sir Henry Maine and others, E. Hobel, M. Gluckman, S. Diamond. Now, historical school basically deals with the importance of using historical experiences for making laws. Savigny is credited with making prime contribution to the historical school. According to him, the common consciousness of the work means the people, can be only true source and substance of this positive law. So, he is saying that law is based on the consciousness of the people, so which are the true source of making law. It is primarily via customs, habits, practices and beliefs of the people. So, this is the sources of law basically, customs, habits, practices and beliefs. Law is not universal, he says, and varies with people, time and needs of the community. So, it says law needs to be changed, it should not be a static one. According to many, the source of law in early societies took various forms such as customs, which is then followed by courts, and in the progressive societies by fiction, equity and then finally legislation. So, he says law, though it is derived from the custom, then it was followed by courts, and in any progressive society then further based on the principles of equity. So, finally the legislation which make the law that governs the state. Sociological jurisprudence. Now, if we look into the concept of sociological jurisprudence, the Eyring, he laid down first foundation of sociological jurisprudence. He propounded theory, law as a means to an end. He said that law is an instrument for serving the needs of a society. For example, now sociological jurisprudence, if we look into, it says, law is a means to an end. That means the purpose of law is to make, to achieve the interest of society. So, law is an instrument for serving the needs of society. Now, if we have to look into an example, the company law exists because it serves the need of business. He said that the purpose of law is to further and protect the interest of society. Now, he was of the opinion that human beings have both selfish and unselfish purposes in life. So, a person can have a selfish or an unselfish purpose, but the purpose of law is to protect the interest of society. Law has to suppress the selfish purpose of a man. For example, the selfish purpose of killing for money is prohibited by law. He said that the law does not exist for the individual alone, but for the society as a whole. So, law cannot exist for an individual, but it has to be for the progression of a society. He said that there were three types of interest. In any society, it could be individual interest, it could be societal interest and the state interest. Now, he says that these three interests needs to be balanced. So, when we are talking about Eyring, he says both the interests have to be, all the three basically, if societal or an individual or a state interest, they have to be balanced. For example, in India, free speech is a fundamental right for the individuals. However, the state interest allows the government to restrict this free speech of individual when it comes to hate speeches or in interest of public order or interest. So, according to Eyring, it was necessary to reward the good and coerce the bad. Now, after Eyring, there was also, from the school of social jurisprudence, Friedman, who in his book Law and Changing Society has discussed the paradox of whether law influences the society or the society influences the law. The answer to the question is quite nuanced. At times, law influences the society, at times the society influences the law. So, let us consider some example here. The presence of social evil of dowry, if we look into, the government was forced to pass the law making it illegal to give and take dowry. Now, initially the presence of dowry in the society influenced the government to pass the new law, but later passing of this law against the dowry, it's influenced the society in reducing the practice of dowry to some extent. So, if we look into the other view of Max Weber, he was first to develop a systematic sociology of law and graded the rational quality of law and its stages and concluded that there is a causal connection between law and capitalism. There are many other jurists also, scholars who propounded upon this concept of law and through the sociological approach they have used, like Leon Duguet. He follows the view of French socialist Emile Durkheim and considers that norm of objective laws are based on law of solidarity. So he bring out the concept of social solidarity. Now social solidarity occurs when people have common needs which can be satisfied jointly, and when people have different needs and different abilities which can be satisfied through the exchange of mutual services. Similarly, jurist Ehrlich, he is from Australia, he also contributed to the impact of law on society. He believed that formal sources of law give inadequate picture of society. He said that there was some divergence in the law as it existed in the books and as if it worked in the society. Now he came up with the idea of living law, which is the law as it works in the society. He framed the living law concept. To discover the living law, he says one has to go beyond the formal sources and check the judicial decisions, the modern business documents, and observe the people behavior. For example, we do have law prohibiting dowry as we have discussed, but dowry is still taken. We can observe this reality from the behavior of the people. So Roscoe Pound, a professor for Harvard Law School, he gave importance to take into account social facts. So law is a social engineering, which means a balance between the competing interests in society, in which applied science are used for resolving individual and social problems. Therefore, it is necessary to make social investigations before making the law. France in the year 2010, if you look into it, passed a law banning veils or burqas and a dress covering entire body. So this law faced opposition from citizens and international bodies as being discriminatory towards the woman and certain religions. So law has to take into consideration social facts also. Similarly, if we have to, now we have gone through various national law theories, legal positivism theory, historical and anthropological school. However, there are certain changes which come in the 20th century. Maybe we will discuss that in our next video or a next session, where we will be continuing with the other philosophical approaches to the concept of law. However, to summarize, we can say the philosophical theories of law, which is advanced by legal theorists, are of particular value and help to understand the nature, concept and functions of law. The natural law theory provides that law is lex naturalis, it is universal law and is set by nature. Bodin, Hobbes and Bentham Austin believes in the idea that law is a command of the sovereign. This is an analytical view. Hobbes' social contract theory justifies authoritarian government or absolutism sovereign. Positivists regards law as the expression of the will of the state through the medium of legislature. So von Savigny, as main representative of historical and anthropological approaches, provide that law has its existence in the general will and customary observance is not the cause of law, but the evidence of its existence. And the Manet contrasted earlier societies with progressive societies. The source of law in earlier societies took various forms, such as customs followed by codes, and the progressive societies, and in the progressive society further friction, equity and finally legislation. So sociological jurisprudence emphasized on law as means to an end, living law, social engineering, balancing the competing interest in a society. So with this we conclude this session, and I think in the next session we will continue with nature of law in 20th century as per philosophical school of jurisprudence. Thank you.